I commend this bill to the House. Thank you, Mr.
I call the Honourable Nanaia Mahuta. Tēnā koe.
Tēnā koe. I too want to make a contribution to the third reading of this bill, and unlike members who have spoken before me who have aptly covered much of the detail of the bill, I want to speak in some general nature about some of the learning points from the opportunities provided in this on-account settlement, because to understand, I guess, the total, the full interests of Whanganui in the region, we would have to look at the various compositions or component parts of their historical claims, and it has been with some interest that I have seen the way in which the Whanganui iwi have innovated an approach to deal with overlapping interests and the nature of their distinct boundaries within their larger collective group. So the fact that they have an on-account settlement that ensures that the Ngāti Apa interests in the south of Whanganui are provided for under this particular bill does not detract from any of the other subsequent interests of other component parts of Whanganui iwi within Whanganui, and I think that's a good approach. We've had a number of settlements before the Māori Affairs Select Committee as I speak, who seem, with their own historical peculiarities, unable to resolve some of the overlapping interests, some of the overlapping claims and some of the contesting of their boundaries. So I think that there is good learning from this particular settlement. And can I say that the treaty settlement redress that has been brought about through subsequent claims, and certainly our understanding as parliamentarians as to how that is all made up, has been really supported by the innovation of iwi to deal with their own complex issues. And again, an on-account settlement is a creative and innovative approach to addressing overlapping interests while not impeding other parts, component parts of an iwi's claim. And we haven't seen this type of approach used too often, but it should be a learning opportunity for other iwi who want to pick up the really difficult challenge of advancing their settlements. On some of the detail of the bill, the fact that a half share of the land of Kaitoke Prison will be offered back to Ngāti Apa may present further opportunities for them. Obviously, being a landowner of a prison and a manager of a prison is two different things, but it certainly does present Ngāti Apa with an opportunity on that front. But can I say this? I'm absolutely sure Ngāti Apa do not want to see more prisons in their region. They're probably wanting to realise opportunity that gets their people out of prison and into productive parts of our society and contributing to our communities. And I say that with a level of confidence because I'm sure a lot of people from Whanganui would be happy to see the demise of prisons in their communities and the full utilisation of the skills and expertise of their people building their people wealth and their economic wealth. So only time will realise whether that is an empty statement or a real aspiration, but it is an opportunity for Ngāti Apa. Also, the value of the Whanganui forest in terms of Ngāti Apa's interest in planning for the future, I think that too presents a real opportunity for Ngāti Apa, and it will be an accelerant for them to reach their development aspirations. Mr. Speaker, we spent some time in the committee stages of the bill debating the issue of Whanganui and including the H, and we took on board the recommendations of the Māori Affairs Select Committee. It doesn't really mean too much to myself with our dialect up in Tainui, because we've always referred to Whanganui as Whanganui. Whether or not the H was recognised in the word, we have always said Whanganui. And what the Select Committee has done is they've formalised the appropriate spelling of Whanganui, and they've amended that in this particular bill. The other part that I wanted to briefly comment on, Mr Speaker, is an issue that was raised by Tūrurua Flavel in terms of the other component parts of Whanganui interests, and especially with regards to their river claim, their impending river claim. It seems to me that the opportunity once again for Whanganui to continue to advance some larger aspects of their historical claims will add another strong foundation or strong pillar to the ability of Whanganui to plan for the future, to be able to have a vested interest in the protection of their beautiful river and contribute to long-term decision making within their region. And I say that with a level of insight, because I've had the honour of being hosted down the Whanganui River, and I know that it is one of special significance and sacred meaning and value to the people of Whanganui. I note with interest the contribution of the Green member, who said in this day and age we have moved well beyond some of the views that are starting to rear itself out in the public domain about Māori getting too much. The resolution of historical injustice is an absolute necessity in order for our nation to move forward, to plan forward, and to ensure that Māori can contribute positively to the shape and identity of the nation that we all want to see. And that's the kind of nation where everybody is valued, where the historical injustice has been resolved. Sometimes you can never take away the hurt of the past, but working towards resolution and redress and reconciliation, I think, is a positive way for our nation to go forward. All those pillars and elements of resolution are contained within this small bill, Mr Speaker, and I think that it's important to recognise that and not underestimate the value of the transformation that can happen within settlements like this. I want to thank the Māori Affairs Select Committee who considered these issues. Now, as a current member on the Select Committee, I'm acutely aware of some of the limitations that we have when it comes to treaty settlement bills, and being unable to significantly comment on the substance of treaty settlements, but neither would we want to. But we do have to continually remind people who are making submissions on bills like this that the Select Committee is limited in its capacity in terms of being able to make recommendations of substance that can in fact be enacted by this Parliament. However, if the Māori Affairs Select Committee is an avenue to cast an eye over some of the substantial matters dealt with in treaty settlements, looking to some of the technical aspects, ensuring that the intent of the deed marries up with the articulation of legislation, then I think that's a very valuable role of the Select Committee. I want to thank the clerks of the committee for their hard work, the advisors to the committee, the officials, and certainly, last but not least, recognise the negotiators, a young team, but the negotiators of this particular on-account settlement for their wisdom, I think, in trying to find a pragmatic solution, but also something that resolves some of their historical hurts, but also looks to the future. Nō reira, Mr Speaker, tēnei e mihi atu kia rātou no Ngāti Apa, I raro I ngā whakaaro hei tutuki tēnei wāhanga mō a rātou nei krimi. Tēnā koutou.